This is part 2 of our Viewer's Guide to the Healthcare Argument, where we provide you, the viewer, with an explanation of the Obamacare issues pending before the Supreme Court. Joining us to discuss the individual mandate issue is Richard Epstein. He is a constitutional law professor at New York University School of Law. Welcome, Richard. Thank you for joining us today.
I'm very pleased to be here.
So the individual mandate is essentially the heart of Obamacare. So what's the requirement exactly?
This is a requirement which says that those individuals who are not covered by a private health care or on some public program like Medicare have to either get insurance for themselves or pay a certain fee to the United States government because they have not gotten that kind of care. So essentially it's an order to either get insurance or to pay money into the federal treasury.
Well, and the penalty can be up to $3,000 a year, but what's the reason for this mandate? Why did Congress find it necessary to include it?
Well, there are two reasons that are given, and they're somewhat in tension with each other. The first reason is that everybody eventually will need health care, and if you don't take out some kind of protection, it means that you will free ride on other individuals. But given the structure of the plan, the more pressing need is the opposite, which says that if you wish to insure people with high risk at low rates, then you must force people who have low risk to pay high rates. And so the mandate is designed to make sure that you could balance the budget. And they call this in some sense a penalty, but in many ways it functions as a tax. And there's a huge set of constitutional issues about which characterization is correct.
Well, and I want to get into the constitutional issues because isn't it a question before the Supreme Court whether or not Congress has the authority to create this mandate either via the Commerce Clause, the Necessary and Proper Clause, or the General Welfare Clause?
Yes, that is correct. And let me sort of state to the audience what these three things say. And the first one, the Commerce Clause, counterintuitively for these purposes, says Congress shall have the power to regulate commerce with foreign nations among the several states or with the Indian tribes. And the Necessary and Proper Clause adds to that scope by saying Congress can pass all legislation that is necessary and proper for carrying these particular mandates, that is, the use of its power under the Commerce Clause, into effect. And the Spending Clause says Congress shall have the power to tax and to spend, and this covers common defense and the general welfare of the United States. And so the question is, how amongst these three provisions can you defend the constitutionality of the original of the individual mandate?
So do you think the issue is going to ultimately come down to whether or not there's a connection between an individual's health care decisions and the interstate commerce?
Well, it's certainly going to have to come down to that particular question, but I think it's important to understand the way in which the arguments play out. Right now, the Commerce Clause is construed quite against its original intention in an exceedingly broad passage sense, so that under the decisive 1942 precedent, somebody who feeds his own corn or his own grain to his own cows is engaged in interstate commerce because the aggregation of large numbers of transactions of this sort are said to influence the quantity and the price of goods that are shipped in interstate commerce. This goes even beyond that by saying, even if you've not chosen to act in commerce, the government can somehow or other conscript you into this particular program. And so the Necessary and Proper Clauses said, since this is part of an integrated scheme, either you allow Congress to impose this thing, or they cannot do things that are surely within its power today, which is the power to regulate health care, as, for example, through Medicare. And the spending argument is that even though Congress called this a penalty, what it really is not a penalty, it's some kind of a tax. Now, I've actually written briefs on the other side of this case from the government, and let me see if I could put the argument on the opposite side so you could at least understand it.
That would be great.
The first point about this is that it's quite clear that this is a novel extension, and the issue is whether or not it is necessary and proper to do so. And the counter-argument is as follows. There is a regular system of taxation that is available, and what that system does is require you to impose a general levy on all individuals and then to spend it to cover the shortfall that comes under the plan. Congress could not get the votes to do this. But to say that it's necessary and proper to impose either a penalty or a tax on a small segment of the population is a stretch, given the fact that this other means of financing is available. And note, too, that if you tried to do this by a tax, there's no way you could draft a tax which would impose it upon itself exclusively on those individuals who have relatively low risk. It would have to be as part of the general progressive tax system, and everybody would be in it. So since there's a cheap and alternative way to do it, the fact that you've now gone beyond conventional means in dealing with this question suggests that the president doesn't have to do this. And the fact that he could not get it through Congress in the traditional form suggests that an important function of checks and balances is at stake. Namely, the fact that if we have a regular process and you can't win in the democratic system through that process, you should not be allowed to use ad hoc processes in order to achieve the same result. And that's the nub of the case against the mandate, and to say that they have to start over on this particular feature, at least with respect to the financing of the bill.
All right, thank you, Professor. You certainly have an opinion there, I can tell, but we're going to have to leave it there. We're going to have to leave it there for now, but thank you, Richard Epstein of NYU School of Law. Stay tuned for the next installment of our series. But in the meantime, for more information on this topic or others, log on now to BloombergLaw.com, and you can follow us at Spencer Mazyck on Twitter. Bye, everybody.